Maruti Suzuki records highest ever sales and exports in the first quarter of a year. New Swift sells over 35,000 units in less than a month. Three new laws come into effect today. They replace the Indian Penal Code, the Code of Criminal Procedure and Evidence Act. Amit Shah says justice replaces punishment in them. Opposition says they were passed forcibly by suspending 146 members of the parliament. Karnataka releases a draft bill to protect the rights of gig workers, proposes a fee to be charged to platforms for each transaction towards gig worker welfare. Ola Electric plans its IPO of 7,250 crore rupees. The company also aims to invest $100 million in Ola Gigafactory to start feeding its future factory by early 2025. France's far-right leader Marine Le Pen wins the first round of snap elections. President Emmanuel Macron's centrist alliance comes in third place. The Prabhas Deepika Padukone starrer Kalki 2898 AD crosses the 550 crore rupees in collections worldwide, and this is just day 4 of the film's release. Good evening and welcome. You're watching The Big Story on NDTV Profit, and I am your host Nupur Talwar Suri. Now on the show, we will be discussing the new criminal laws that have come into effect from today. The Bharatiya Nyaya Sanhita will replace the Indian Penal Code. The Bharatiya Nagrik Suraksha Sanhita will replace the Criminal Procedure Code, and the Bharatiya Sakshya Adhinayam will replace the Indian Evidence Act of 1872. What's new about them? Well, the new laws aim to simplify the legal procedures such as filing of FIRs and online registration of police complaints. There is also provision to speed up justice delivery. Strict deadlines have been written in for trial courts to deliver judgments within 45 days. The Home Minister Amit Shah has addressed a press conference where he emphasized on how justice will replace punishment. Listen into what he said.
ये कानून जब आज से हर थाने में अपना काम करना चालू करेंगे, तब अंग्रेजों के बनाए हुए कानून निरस्त होकर भारत की संसद ने बनाए हुए कानून आएंगे। दंड की जगह न्याय लेगा, देरी की जगह स्पीडी ट्रायल और स्पीडी जस्टिस मिलेगा। और पहले सिर्फ पुलिस के अधिकारों की रक्षा की गई थी, अब पीड़ितों के अधिकारों की रक्षा और जो कंप्लेनेंट है इसके भी अधिकारों की रक्षा करने का काम होगा।
Well, our first guest is Senior Supreme Court Advocate and former Union Minister of Law and Justice, Ashwini Kumar. Good evening, Mr. Kumar. Welcome to our Big Story, our special show on this. Mr. Kumar, to begin with, now this is a move that, intends to completely overhaul the justice system. How do you see this impacting the legal system and also justice delivery? Do you see it as a landmark change?
Well, there's a lot of controversy about the replacement of the old architecture of the criminal justice system with the new laws. And the principal controversy centers around the fact that in substance, nothing new has happened, in the sense that the anti-civil libertarian provisions of the old laws have become worse. The pre-trial custodial investigations could be, the time for that could be increased from 15 days to 60 days and 90 days. The sedition laws are back again in another form. The much needed anti-custodial torture legislation has not been enacted or made part of the comprehensive legal reforms claimed by the government. To the extent that technology is being used to speed up justice, this is welcome. To the extent that the criminal justice system will now, as claimed by the Honorable Home Minister, be centered around the victim and the complainant, and not be focusing on the penal effects of the crime. That is a welcome development. But many academics, many jurists, many lawyers, and many ex-judges have expressed grave doubts about whether all of this is going to happen. Now, just to give you an example, there are about 650 district courts, and there are about 16,000 odd police stations across the country. Whether the personnel in uniform who are in charge of the enforcement of criminal laws have been fully trained and and made to be aware of the intricacies of the technology and of the aims of the new law is doubtful. I've received reports suggesting that hardly any in-depth training of the new legal architecture has been extended to those who are supposed to be enforcing it. So there are some issues. And the opposition has rightly said that before these laws were passed, there was no meaningful, in-depth, comprehensive deliberation on the architecture of the new laws. Please remember that 146 MPs were suspended from the House. Neither in the concerned parliamentary committee nor in the House, we are told that extensive deliberations have taken place. So criminal laws affect every single citizen of this country. I think it is a legitimate demand of the opposition and of the other stakeholders that these laws, which have since been passed by Parliament, should be revisited, not only for the purpose of criticizing them, but for the purpose of making them more effective and more justice-friendly. This is the crux of the matter. And I think a responsive democratic government should concede this legitimate demand of the opposition.
Right. Mr. Kumar, do stay with us. As you were pointing out, the opposition, of course, has hit out saying that they weren't consulted and enough consultations were not held on this. But the Home Minister has hit right back at the opposition, negating the claims that the bills were brought after the mass suspension of MPs. He said that maybe the opposition did not want to participate. Listen in.
कुछ विपक्ष के मित्र अलग अलग बातें मीडिया के सामने रख रहे हैं कि अभी ट्रेनिंग नहीं हुई है, चर्चा नहीं हुई है। मैं आप सभी को बताना चाहता हूं कि लोकसभा में कुल मिलाकर 9 घंटा और 29 मिनट चर्चा हुई है। 34 सदस्यों ने इसके अंदर पार्टिसिपेट किया है। राज्यसभा में 6 घंटा और 70 मिनट चर्चा हुई, 40 सदस्यों ने पार्टिसिपेट किया है। एक ये भी झूठ चलाया जा रहा है कि सबको बाल निकालने के बाद ये बिल लाया गया। बिल बिजनेस एडवाइजरी कमेटी में पहले से निश्चित था। मेरा ये स्पष्ट मानना है कि 14 तारीख से ही विपक्ष ने सदन का बहिष्कार करने जैसी हरकतें करी थी और शायद वो हिस्सा लेना नहीं चाहते थे।
Mr. Kumar, that was the Home Minister. Would you like to respond to that? And the other point that I wanted to, bring up with you was that one of the significant changes is the extension of police custody duration from the previous 15 days under the CRPC up to 90 days under, the BNSS. Now, while obviously the government argues that this will expedite trial, there is been a fair amount of criticism saying that this could potentially be misused. How do you see it?
I'm absolutely certain it will be misused. The need of the hour is to make laws benign, not to make them more draconian. Where is the need for endless custodial interrogation of people? And we know that in the absence of an anti-custodial torture legislation in the country, about which internationally Government of India has been censored for not bringing in such a legislation, the possibilities of police torture in custody will only increase. In fact, this was the time to drastically curtail the period of custodial investigation. No civilized country in the world has that kind of extended custodial arrests for the purposes of pre-trial investigation. It is an absolutely draconian provision, and I tend to agree with the view that this is a backward step, not a forward step in the rehumanizing of our criminal justice system. We all know that as far as the implementation of the criminal laws is concerned, it is left to people who are largely untrained, quite I should say, ruthless in the manner in which they investigate people, regardless of the human rights guaranteed by the Constitution. In such a scenario, there was need to have inbuilt checks and balances against the excesses of the custodial, of the investigating agencies of people in custody. I would also like to say that as far as the claim of deliberation and discussion on the laws is concerned, it is not the number of hours that are technically taken up for discussing things. It is how deeply and how thoughtfully the laws have been discussed. In the kind of pandemonium that prevailed at that time when 146 MPs were expelled, nobody can reasonably expect thoughtful, deliberative exercise on criminal laws, which are so very important for the individual liberties of citizens. We cannot now convert ourselves into an anti-civil libertarian state in the garb of replacing old colonial laws with the new laws. The new laws have to be better in terms of the constitutional jurisprudence of human rights, in terms of their ability to advance the constitutional objective of securing the fundamental human rights and liberty of Indian citizens.
All right. Now, the other part of it, Mr. Kumar, is that the government says that this is going to speed up the justice delivery system because the new laws now require that judgments have to be delivered within 45 days and trial and charges have to be framed within 60 days of the first hearing. How do you read this? You know, because there is some amount of apprehension.
You know, there's a trite saying in law that justice delayed is justice denied. But it is equally true that justice hurried is justice buried. Now, if you want to stick to the timelines prescribed by the statute, please understand the number of cases that are to be tried. Do we have that many courts that would be able to try within the time stipulated the cases before it? Do we have that many judges? Do we have that kind of technological dissemination across the judicial system, which will enable technology to render speedy justice? And if indeed speedy justice and effective justice and real justice can be achieved, nothing like it. I would be the first person to support it. And I think to the extent that government has introduced the e-filing system and the use of video recording for recording the item seized and also recording the investigation, that is a good step forward. But what is the extent to which these technological initiatives will secure the fundamentals of criminal justice is to be seen.
Mr. Kumar, thank you very much for joining us on the broadcast and sharing your views on the new laws that have been put in place by the government.
Thank you very much.
Well, now talking about the law implementation of the 3 new laws, the Home Minister Amit Shah said that it will not take more than 3 years to get justice from the Supreme Court. Listen in.
इस कानून के संपूर्ण इम्प्लीमेंटेशन के बाद और कुछ तकनीकी तैयारियां करनी है, ये तकनीकी तैयारियां होकर थाना और कोर्ट नोटिफाइड होने के बाद किसी भी न्याय मांगने वाले व्यक्ति को एफआईआर की डेट से 3 साल के अंदर सुप्रीम कोर्ट तक न्याय मिल जाएगा, इसका मुझे भरोसा है और कानूनों में इस प्रकार का हमने प्रावधान किया है.
Speedy justice delivery, that is what is the crux of these new laws. Joining us are a senior advocate at the Supreme Court and former additional Solicitor General Siddharth Luthra and senior lawyer at the Bombay High Court and the Supreme Court, Swapnil Kothari. Swapnil and Siddharth, thank you very much, both of you, for joining us. If I could come to you first, Mr. Luthra, these are new criminal laws that essentially bring in a host of changes to the colonial era justice system framework. Broadly, how do you see them?
So I would say, first correction, it is some changes, but I would say about 80% of the law remains the same. It's really restructuring, renumbering, reorganization. And therefore, what's important for us as students of the law, 80 substantial portion of the jurisprudence, the judgments of the past will continue to apply. There's going to be no revolutionary change in that sense. The change comes in the detail because let's look at the 3 legislations. Legislation 1, you have the penal code, the new avatar is BNS. Don't forget, the BNS and the penal code are laws in 33 countries other than India even today. Having said that, this legislation brings in now organized crime, it brings in terrorism, it takes out sedition but brings in secession, which is really effectively Section 13 of the UAPA. It also brings in mob lynching, chain snatching. Most important, it brings in community service. Doesn't broad base it as much as I would have liked, but it brings in community service. So that's the one part. It rationalizes punishments, fines. In some cases, there's an enhancement of punishment. It tries to get over some old judgments of the Supreme Court, which had struck down certain provisions. So that's the broad structure of the law. The attempt is to bring in coherence, add a few provisions. Now, the catch is going to be in the detail, which is to say, what is going to be applied if you apply the definition of terrorism here, or you apply the definition of organized crime here, or you apply the definition of what is now secession here. What about the special laws, the UAPA and the NIA Act and the Maharashtra Control of Organized Crime Act, which have special restrictions and special procedures, reverse burdens? Thank God the reverse burdens are not here. Thank God the restricting conditions of bail are not here. But all those issues are missing. So which will an investigator choose? And in the case of the organized crime, the superintendent of police has the jurisdiction. Added to that, and let's look at it a little more further, the point is the terms in organized crime are not very well explained. Now, any law needed to change. It's been 160 odd years. There has to be improvement in change. We had to deal with technology, as your screen says, gender. We had to rationalize certain provisions. We had to see what contemporary terms say. We had to see what technology does. So let's look at your second bit of legislation, which is the procedural law. Trial guidelines, 2 adjournments, no more. Investigation to be concluded in a limited time. Powers to the police to take custody up till 640 days or 60 days, though the period of custody remains 50 days. But there is a safeguard in section 450. It says, this shall not be a ground to refuse bail alone. So there is an attempt to rationalize. There is a greater focus on technology. There is a greater focus on EFIRs. There is plea bargaining is sought to be fine-tuned, however, and victims to be given greater rights. But the point is, when victims may get an FIR, but today victims can download the FIR off the website anyway of most police services. So while there are these changes, and a lot of changes have been brought in through statute, and it is important, the devil lies in the detail. Do we have the infrastructure? We trained our police officers, yes. We've trained our judges, yes. And judges, lawyers are used to dealing with new laws. That's part of their training from law school onwards. When we came to law school, we didn't know the law, we learned it. We've still learned it. When you brought in PMLA, we learned it. When you change the Corruption Act, we learned it. This is just a larger exercise, but it's not that big a deal. The problem is the devil lies in the detail. How are these federal and state issues going to work out? You say, if for forensic exercises, you're going to have video recording of arrests, you're going to have video recording of seizures. Where is that data? How are we going to preserve it? What are the devices? So those details have to be fine-tuned. You also have a situation where you're going to talk about, allowing police officers to use mobile phones or smartphones. So should the government not have already issued smartphones to all its police officers? And these are smartphones which are important because this data that is recorded on them is going to be primary evidence. That's the new change in the law. Now let's come to the evidence law, the BSA, the Adhiniyam. The Adhiniyam is now a little more interesting. It allows corroborated confessions of co-accused. That's a matter of some concern. It was being not allowed earlier. They have opened up the arena of electronic evidence, knowing that technology is changing. So it's a forward-looking part. I think that's great. On the other hand, it has relaxed the rule of relevancy. I'm a little concerned with that. It has accepted expert witnesses almost as the gospel truth. So there are some issues that will have to be dealt with the evidence law. But fortunately, no reverse burdens have been added. Fortunately, other restrictive covenants have not been added. So broadly to say, it's something we will have to learn, we'll have to work with.
Right.
We are, any legislation in the Western world, in the UK, for example, all legislations are tested every 10 years. So when you test a legislation every 10 years, you see and you review it. You're looking at seeing what improvements, what deficiencies have been done. The devil, as I said, lies in the details, and
Absolutely.
therefore, wherever there are nebulous terms, wherever things are left open-ended, wherever there's executive power, whereas there is the ability of state authorities to exceed authority, that's the place where the courts must be vigilant and ensure no breach of fundamental rights. Technology, I must tell you, is an enabler, but it's the biggest restriction for abuse of power.
All
An
right.
officer who is recording something, or who, while questioning, is
Right.
being put to a video recording, knows that he ought not to use third degree methods.
Absolutely. So
Let's see how this works out.
as you're saying, obviously, we'll have to see how this is actually implemented. I'm going to bring in Swapnil now. Swapnil, what do you make of this, what is being described as a significant change? And do you share those concerns that Mr. Luthra just spoke about?
Nupur, it's always a concern when it comes to implementation in this country. We have always sufficient laws, but the implementation is disastrous. You're seeing it in the Pune Porsche case. Where are we at that regarding that case? Still somewhere in limbo. The police has gone and appealed to the Supreme Court. So let's see what happens, what transpires there. Now, in addition to the things that Mr. Luthra mentioned, I think some of the key factors are that those evading arrests can also be tried in absentia. So, for example, if somebody absconds from this country, Fugitive Economic Offenders Act always wanted extradition treaty, etc. So I think that we can do away with that, and we can still try him or her in absentia, whoever it is. It's gender neutral now. You have 3 genders, as I can see it on your screen. That, of course, is very important. 20 years for gang rape, 20 years to a lifer. So Beti Bachao, Beti Padhao is actually being put into action by increasing the length of the sentences or the severity of the sentence. 1 year jail for people who bribe voters during elections. Now, how important is that? We've seen a lot of nonsense that was going on prior to the election, where the mayor tried to overturn the election in Chandigarh, the election results, electoral bonds judgment. So the Supreme Court was very clear as to what it wanted to do. And I believe that the government, of course, had done all these changes prior to these 3-4 judgments of the Supreme Court. But I think the government knew that it had to toe the line, and it had to ensure that, look at the broad conspectus of our democracy and not just certain penal provisions. Basically, this is just old wine in a new bottle. It amounts to an overall, in certain aspects, you've added some things like mob lynching, etc., can still, merit a capital punishment. So in that sense, the law is extremely progressive. But now to say that within 3 years, you're going to be able to go to the Supreme Court, only 2 adjournments, 45 days, some sort of a conclusion on the FIR, I don't think that is going to be really possible, given the kind of delays that we have, given the kind of adjournments, possibilities that lawyers can come out with, and given the laxity or the leniency with which courts often function in this country. So unless and until you have some sort of a Singapore-based rules on arbitration and all those things, which I don't want to get into, except that they have a very limited amount of time for lawyers, limited amount of adjournments, and it's over and done with. And the same way the Supreme Court of the United States also functions, that you have limited time for arguments. That's the reason why before it closes for vacation in summer, the Supreme Court of the United States does not have a single case pending. So I don't want to get there, because it's comparing apples and oranges, where you're comparing 270 years of independence with 70 years, and obviously 1/3 of the population which is there in the United States, as opposed to we are 3 times their population. So Nupur, the question that merits attention and which is going to really, really plague all of us lawyers, and I think we lawyers have a fundamental duty here to ensure that we actually give teeth to these laws. Then, because we are officers of the court, so we have to assist the court, Nupur. And if we don't do that, then we are as much guilty of trying to delay, have procrastination tactics, dilatory tactics as the terms that we use in law. All of these things really, because ultimately you have to serve the client, but at the same time you are an officer of the court, so that adequate balancing has to be done. And let me tell you, Nupur, equal amount of abuse of that takes place even in civil practice. not only in criminal law practice. In terms of adjournments, in terms of trying to dilly-dally, give some stupid defenses, this, that, and the other. So that is something which we'll have to take a look at. And of course, lawyers have to be, last point, very conscientious in trying to take up the kind of cases that they do. When it comes to, I would not have taken up the Pune Porsche case for the, the person who's for the accused. But that's okay. That's a different moral story altogether. I don't want to get into that part.
Absolutely. Absolutely. So as both of you seem to suggest, a lot will lie in the details, how this is implemented. Mr. Luthra as well as Swapnil Kothari, thank you very much, gentlemen, for joining us this evening.
Thanks, Nupur.
Thank you.
All right. So on that note, it's a wrap on this big story of the 3 new criminal laws that come into force today. Thank you very much for watching.